purpose of this is to guide judges and lawyers when they're actually arguing and briefing cases. Currently, before the Restatement of Employment Law, you had to look at contracts, the restatement of contracts, the restatement of agency. You weren't always finding the information you needed for an employment law case. We are taking issues that are special to the employment relationship, and we're focusing sort of the dynamic analytic power of the restatement process on those issues.
What restatements do, I think, that is a little bit different from what other treatises do. And there are lots of different ways to describe it. But restatements do more than simply kind of quote what the law is at any given moment in time. They also clarify and improve. What the Restatement of Employment Law in particular, I think, does both very competently, insightfully, and thoroughly is to identify existing majority trends, identify strong minority trends when those exist.
First of all, restatement has to be tethered to the cases. If it's just coming out of someone's head, it's not going to be helpful. It's got to be a reflection of the existing law.
What it provides both the practitioner and the judge is a picture that is broader and deeper at the same time. So, for example, there is a great deal of work on employee privacy and how that is to be protected at the workplace, particularly when the workplace is now open to reconfiguration as many people work remotely. Where is their office? Is it in their laptop? Wherever they may be. As people are communicating in ways that could be disseminated well beyond what we traditionally think of as the workforce or the workplace, and a willingness to take on those difficult issues.
What's special about the restatement is it's not just professors cooking up new ideas. It is coming up with formulations that are tied to the cases, tied to what state courts and other courts are actually doing, and sort of synthesizing all of that experience into a rule that makes sense. The Institute represents all the different branches of the profession. Corporate lawyers, plaintiff lawyers, judges, academics, that's number one. Number two are the folks on the council and among the advisors are very experienced lawyers and very practical lawyers.
I would think it would be an enormously helpful and efficient way of getting the kind of information that a busy judge, a busy arbitrator, a busy mediator, not just arbitration, but mediation too, could turn to. Got a real quick question, what happens with this set of issues, this set of problems? Here's the book, one volume, flip through the table of contents, here it is, very helpful. Here's the framework for analysis. Here are the major trends that courts have been following. Here's where I can find the leading cases in my state, in my jurisdiction. Bingo.